Good morning. See, it was after Second World War when America and other European countries concentrated to maintain capitalism. On the other hand, United Soviet Socialist Republic (USSR), now Russia, concentrating on communism. So therefore, when question of communism and socialism come into force, so all the government were concentrating on bringing laws of labor laws. So India is also one of the such sovereignty to bring some labor acts. So understanding labor laws, you must first understand the Factories Act, because the Factories Act is mother act for all other acts or other labor act. So many labor, Industrial Dispute Act, Trade Union Act, Minimum Payment of Wages Act, ESI Act, so many acts are parent act is Factories Act, Workman Compensation Act, Maternity Benefit Act, so many acts. The question arises, if you want to know labor laws completely, so this judgment would definitely help you to understand the labor laws, because this judgment referred so many other judgments wherein this Factories Act, the scope of Factories Act has been explained. But the judgment which I am going to share with you, AAR 2026 Supreme Court 601, AAR 2026 Supreme Court 601, Union of India and others, Heavy Vehicles Factories Employees Union and another. Actually what had happened, this case pertaining to how to calculate overtime wages. So whether at the time of overtime wages, HRA, TA, SFA should be included or not. This is what the question arises. The government, this is Heavy Vehicle Factories, the managing authorities, periodically issued a memorandum to exclude certain allowances being calculated for overtime wages. So that being the case, the tribunal, administrative tribunal orders were set aside by High Court Division Bench, therefore Madras. Then this case went to Supreme Court. Supreme Court has categorically held when statute provides for only two specific exclusions, bonus and wages for overtime work, in the absence of any formal rules governing exclusion of other entitlements, executive cannot, through mere office memorandum, read additional exclusion into act that legislation did not contemplate. Further, when employees had been in receipt of overtime allowances calculated by including HRA, TA, SFA for considerable duration, sudden exclusion of these allowances via office memorandum lacked legal authority and was contrary to the literal mandate of Section 59. This judgment you have come to Union of India versus Heavy Vehicle. Certain paragraph where you can read about understanding labor act. See, at paragraph 2, they say compensatory allowances, house rent allowance, transport allowance, clothing and washing allowance, small family allowance would fall within the term ordinary rate of wages. That is called Section 59(2). So go through that. Then Section 59(2) says, for the purpose of calculation, overtime will only include basic pay and dearness allowances, additional dearness allowance and any other allowance which are uniformly applicable to all government employees. It was specifically mentioned therein. HRA, T and CW are excluded therefrom. See, these all are done. Section paragraph 3, 4 says what is TA being compensatory in nature. All this you should go through that. Then and the Section 3 of General Classes Act is been read with state government period and clarified that commencement of Constitution 7th Amendment Act 1956. State government means government in a state and the central government in a union territory, including situation where functions are entrusted under Article 258A of the Constitution. This is what you must understand. Then they have read about Chapter 6 of the Factories Act. Then Chapter 11 of the Factories Act. Section 113 of the Act. Then they have read out the Bridge and Roof Company AR 1963 judgment wherein basic wages have been decided. Then Suresh C. Baske versus others case AR 1996. Then Govind Babu Salvi and others case AR 1993. Then AR 2020 Mazdoor Sabha versus another case. These all are the cases which are important. You can very well go through the entirety of judgment to understand the labor law. You see, initially everywhere these communist still existing in India, even though communists are not existing in other communist states, but there it is existing in a different way. But here, because very brilliant leaders periodically obtained ratios, white versus cases, so many cases for the laborers' benefit. So this is how I have seen Madam Vaigai, NGR Prasad, Mr. Chandru, Justice Chandru, well, all are arguing for labor cases. This is the way. Therefore, the laborers are always fond of communist leaders because of their intelligence. And if you, being an advocate, you want to be more intelligent, you want to be more attracted by labor or some section of the society, you should undergo the exercise of obtaining knowledge about the labor laws, particularly Factories Act. This judgment would definitely help you in nearing the some sect of the society who need intelligence help from advocates. Best wishes.